Cavalier versus State.
Good morning, Your Honors. My name is Andrew Crawford. I'm here on behalf of the appellant in this case, Henry Keith Cavalier. This is a final judgment imposing a life sentence after a conviction for lewd and lascivious molestation. I'd respectfully ask for 5 minutes for rebuttal.
Sure.
And if the court can please warn me, can I have a minute, if possible?
I'll do what I can.
Thank you, sir. There are 7 issues in this appeal. I would stand on the brief, rely on the issues contained within the brief. I'd respectfully like to speak with each and every one of you about 2 issues. The first issue I'd like to discuss is the introduction of a movie called Trust, which is a Hollywood mainstream movie which depicts the seduction and rape of a young girl in a motel room that was introduced during the trial.
When you say young, you mean like an adolescent girl?
Yes, sir. Adolescent girl, approximately 15 years of age. The state introduced this movie. The purported reason for introducing it was to rebut the notion that the child had learned what she testified to from the movie.
No, they didn't play the whole movie, did they?
No, and that's an interesting point, Judge Northcutt. They did not play the entire movie. Again, this is a Hollywood...
So introducing a clip of the movie would not rebut any such suggestion.
Exactly. Additionally, Your Honor, I think it's crucial to note that the clip, they isolated a 3-minute and 37-second video clip of the most emotional pinnacle of the movie. And I'd add that this is a Hollywood drama, R-rated movie. And they played this for the jury. Now, again, the basis for introducing it was, they didn't actually say in the case below opening the door, but I would argue, number one, that no door was opened here.
Tell me when the notion of trust
Yes, ma'am.
was first introduced into the case.
The notion of trust was first introduced during my opening statement to the jury.
Next?
The next was during cross-examination
Of the victim.
Correct. Correct. But I would add, Judge Crenshaw, that the purpose of cross-examining her on it was to lay the predicate for impeachment of a prior inconsistent statement with a friend with whom she spoke with as she was watching the movie. Number one, she did not tell her mother during the movie that anything happened, and in fact told her mother 3 years prior that nothing inappropriate had happened. Nothing. And she told her friend as she was watching the movie, I think this may have happened to me when I was 4 or 5 years old at my cousin's house. That was the point of mentioning it. And that was inconsistent with her statement at trial, which was that it occurred at Mr. Cavalier's house when she was 7 or 8 years old. Additionally, I don't think by mentioning the movie, it automatically opens the door for them to isolate and play a 3-minute and 37-second clip. Specifically one...
Cross-examining her on the movie, not the substance of your theory?
I'm not sure I understand the question, Your Honor.
Your theory of defense was that she fabricated.
The theory of the defense was that she fabricated after being caught by her mother on Facebook creating false accounts, speaking with other teenage girls or boys over the internet. That was the theory of the case. The theory of the case was not that she learned this, and nowhere during the course of the trial proceedings did I or co-counsel ever suggest that she learned what she learned from the movie and then testified to that. There was no dispute that what happened in the movie is not what happened to her. Additionally...
Well, go back to what happened in the movie.
Yes, ma'am.
That was presented to the jury.
What was presented into the jury was a video clip of a movie where a child comes out in a lacy pink bra and panties, red pink bra and panties.
In a motel room.
In a motel room. You see a gentleman sitting on the bed, middle-aged gentleman, about 30, 35 years of age, white gentleman.
They have a conversation as she approaches.
She has a conversation, she approaches. You see him kissing her on the neck. You see her, you hear him ask her, let me take these off, referring to her panties. Then you hear his fly unzip and his belt unbuckle. And the clear implication is he's raped off camera. She's raped off camera. That's the implication. That didn't occur in this case. Additionally, if any doors were open, those doors were closed. When the victim testified that what happened to her did not happen on the movie. Judge Crenshaw, I'd argue in terms of opening the door, as this court recently addressed in Henderson versus State, which came out in March of this year, if the door is open, there are certain things that the court needs to look at. Number one, just because something is mentioned that maybe the court may consider misleading, false, or incomplete, that does not automatically admit that evidence. The state must demonstrate a legitimate need for the introduction of that evidence. Additionally, this court is to consider the reliability of that evidence. The less reliable it is, the less likely it's admissible, and how wide the door was opened. Again, I would argue that on this record, Volume 7, page 277, the victim in this case specifically said, "What happened to me is not what happened on the video." She said, "The girl in the video was raped, and I was not." The purpose of eliciting that testimony was to lay the predicate for a prior inconsistent statement. Additionally, even if that door was opened, even if it was opened, which I'm arguing it most certainly was not, that evidence is still subject to a 9403 analysis, even if the door is open. The Florida Supreme Court has made 4 specific inquiries as it relates to a 9403 analysis, which is the Taylor case, which I cited within my brief. Number 1, the need for the evidence. I would argue that there is no need for the evidence, especially after the victim testified that what happened to her did not happen in this movie. The second thing the Florida Supreme Court asked courts to look at is the tendency to suggest an improper response, an emotional response. Is a specific factor that they give. And again, going back to this movie, it is a Hollywood mainstream movie, R-rated movie, which by its very definition is designed to evoke emotion.
Tell me this. The fact that it was an R-rated movie,
Yes, ma'am.
Hollywood mainstream, none of that testimony was presented to the jury, was it? They saw a 3-minute clip.
They did. They saw the emotional pinnacle of a Hollywood-produced drama movie, Your Honor. I would argue that that is designed to elicit an emotional response. That's precisely the definition of what 9403 is designed to exclude, especially a lewd and lascivious molestation case. The third factor, which would be the need to establish a material fact. The material fact in this case is whether or not this child was inappropriately touched by Mr. Cavalier. This movie does not do that. And the final one is a curative instruction, and again, none was given. The most similar case that I could find to this was a case from the 11th Circuit Court of Appeals called United States versus Gamry. This is a case out of Georgia, I believe, where a gentleman who owned a rap music company called Hush Money Entertainment had been distributing cocaine throughout the southeastern United States. At trial, part of his defense was that he was a legitimate businessman. He had all these seafood restaurants as well as a rap music company because that's what he did. He was a legitimate businessman. The government, the United States Attorney's Office at trial, to rebut that, allowed the jury to view a rap video that he produced. The artist was retained by his company, and the rap video showed various things that were also attributable to the defendant in that case. For example, he wore specific cufflinks which were featured in the video. He drove a white Range Rover, and he had a specific house that was depicted in the video. The trial court ruled that because of these factors and because they related to the case, that the video was thus admissible to rebut the defense's theory. On appeal, the 11th Circuit found that that was error under the federal 403 rule. And they said because it promoted a violent lifestyle and because the defendant in the case, although there were some similarities, wasn't in the video, didn't write the lyrics for the video, they found that any probative value was substantially outweighed by the risk of unfair prejudice. I would argue that is exactly what we have here. The second, which I feel most crucial issue on appeal, is the bolstering. It's a cardinal rule in Florida that during a lewd and lascivious molestation case or a sexual battery case, that an officer or any witness give the opinion of credibility of another witness. And that is viewed by the appellate courts in Florida as especially harmful when it's a police officer. There's two things for this court to look at. Who said it and what was said? Who said it? Again, precedent in this district and the other district courts of appeal, and actually in the Florida Supreme Court, have made it clear that when a police officer gives his or her version of credibility of a witness, that is viewed as especially harmful given the great weight to a police officer's testimony. Second thing, what was said. An officer or a witness does not have to come out and specifically say, I think this person was telling the truth, or I think that child was being truthful. Specifically, I would note and relate to the Geisler case, which Judge Northcutt, you were on the panel. If the juxtaposition of what the witness said gave the jury the impression that the child was telling the truth, that runs afoul of the prohibition. There were 3 instances here, 2 by a detective, 1 by the teacher. And I'll talk about each of those in turn. But before we talk about the first instance, we need to talk about the fact who the officer was. In this case, it was a lead detective, a gentleman by the name of Detective Mark Kalinda. In the record, you'll note on Volume 8, page 370 through 373, he goes through all of his qualifications. He lists about 4 pages of qualifications. He also has 464 hours of advanced training in child abuse investigations. He tells us in front of the jury. During these classes, I'd like to draw your attention to those records. He mentions the word kinesics numerous times. Some of the things he says about kinesics. Volume 8, trial record 370. I'm a CVA examiner, which is a polygraph, technically a polygrapher. CVSA is a controlled voice analysis test that enables a person to take, if you will, a lie detector test. During that training, they teach you kinesics, which is the study of nonverbal communication. He goes on to say, same page, deviant sexual behavior course. That's a course dealing with the kind of mechanics of how to investigate and speak with victims that have been sexually abused, how to read, once again, their kinesics through body language. 2 pages later, he says kinesic interviews. Once again, the study of body language and how to read it and interpret that. During the trial, he's asked specifically what kinesics is, and he gives an example which I think is very important for this court to note. Basically, you're a parent and you know your child did something wrong. You could read it. You could say, John, you took the cookie out of the cookie jar. At this point, of course, an objection is lodged. The trial court cuts off the questioning. Importantly, 5 pages later, here's what the detective says, and this is on Volume 8. Go ahead. Do you have a question?
Go ahead.
Volume 8, trial record 378. Talking about truth qualification. She had been previously truth qualified by the deputy, but not only that, her age was at the time was 11, and by looking at her and getting a feel for her, I could tell that, she was acting appropriately. This wasn't a joke to her. Who's saying this? Obviously, it's Detective Kalinda. Second thing, does the juxtaposition of this statement give the jury the impression that he's telling the truth? I would argue to this court that it most certainly does, especially when it's read together with his kinesics testimony, which only occurred 5 pages prior to this in the record on appeal. The trial court even notes this. The trial court says, it may not be what he's trying to do, but it sure sounds like what's coming across. He goes on to further say, I got the sense he's saying this child was already being candid and truthful with him, which wasn't what he actually gets to say. Trial court reads back some testimony, asks me, what about this is vouching, and then instructs the detective what he can and cannot do, and tells him you cannot do things like this and say that this child is taking this seriously. Cross-examination happens. He admits he does not videotape the child, despite having the capability to do so. On read and direct examination, the prosecutor asks him, why didn't he videotape this child? And he says, on page 408, we don't as an agency, because we at the Pinellas County Sheriff's Office can decipher if the child has told the truth or a lie. The jury's taken out, denied a motion for mistrial. Clearly, the implication, as the trial court found, was that this detective believed this child was telling the truth because she wasn't videotaped. Not only him, but also the Pinellas County Sheriff's Office. That's the statement that's given.
It's kind of a non sequitur answer too, was it not?
It was. The trial court does give a curative instruction, and I know the state relies heavy on this in their brief. In terms of a curative instruction, the two most influential cases which I'd like to point out in Florida are the Acosta Case, which is a 4th District Court of Appeal case, and the Tumblin case, which is a Florida Supreme Court case. The Acosta case was a grand theft and a forgery, uttering a forged check case. There were 3 people who were involved. Only one person was charged. One of the co-defendants testified against the defendant at trial. And additionally, there was also further evidence that the handwriting examiner found that similarities between the defendant's handwriting as well as the handwriting that was on the check. But there were also some dissimilarities as well.
Just to give you a heads up, Mr. Crawford, you're down to 5.
5 minutes of all my time together? I'll reserve the balance, Your Honor.
Okay.
May it please the Court, Wendy Buffington on behalf of the state appellee in the instant case. Firstly, just wanted to state an objection to the supplemental authorities to the extent that they cited holdings of the case. And that's all. You know, that they should have just cited the issue and the actual case. So as far as the movie itself, it actually was introduced into this case as a subject before the trial even started in pretrial motions. Starting at the motion hearing, there's a cross of the child on the movie. There is the direct of the friend AC on the movie. There is argument regarding the child's lack of reliability, having seen this movie that made the disclosure. There is the trial court. Before the start of trial, there's discussion of experts. Now these experts, Dr. Crum for the state, Dr. DeClue for the defense, were listed to give we don't know what, because they never did get to it. But the trial court addressed that before the start of trial, saying that the unreliability, there's a suggestion of unreliability based on several factors, including, watching of this film.
How does that get the state to showing that clip of the movie?
That wasn't the issue below, that clip was the problem. They could have brought more.
Well, the movie's the problem.
The movie.
And, the fact that the question is whether something was introduced into evidence that was, perhaps irrelevant and or unduly prejudicial.
Right, we have to look at both.
Got to look at both. Well, you don't have to look at both.
If it's not relevant, is that your point?
Right.
You don't have to look
the
at.
The question is, you show a clip of the one scene in the movie, and it's certainly. If I were the state, I know that's the scene I would want to show, but I don't see how any of these things that you mentioned get the state to being entitled to show that movie at the trial.
Okay, the state doesn't talk about this film.
It's case in chief.
Yes, okay, so the state doesn't talk about it in opening, right? And, the state never talks about it until they introduce this clip. And the court, there's a lengthy bench conference regarding, the defense objection to this clip coming in. And so why is it coming in? And the judge says, okay, the state says, I think they need to see it to rebut these claims that have been developed in this trial regarding seeing this. And it's disingenuous, I'm sorry to say, that it was introduced for the fact of just to lay a predicate for impeachment, because at the conference with the judge, expressly, when the judge is saying, well, why is it relevant? If it's not relevant because this didn't happen, why is it relevant? Why have we had it as a subject of all these hearings? Why do we have this these experts listed? And what the import of it, the judge asks, is the value of the movie has to do with the explanation. Now this is the court talking, for why the child made the statement. That, let me slow down because I'm going a little fast.
That's okay.
The value of the movie has to do with the explanation for why the child made the statement. That seems to me that's your whole point. The defense, it is, Your Honor, objection overruled. Prior to that.
But how do you, show just that part of the movie if that's the relevance? Yeah, I think you pretty much, for it to be relevant, you have to show the whole thing, would you not?
Well, no, because if there isn't sexual contact
in the other parts. I mean, if the suggestion is that these allegations were motivated by that, and certainly...
But how does the jury know this?
Because
the jury sees just a few seconds of this movie, and you're trying to show the jury that this allegation that she got her idea from the movie is false. You can't do that by just showing them part of the movie, can you? They would have to see the whole thing to discard that.
If that was the sentiment, go ahead and show them the whole thing.
Point is, I don't, I have trouble believing that that was what the purpose was. Clearly, the purpose here was to show the jury this specific scene.
How about the fact that the judge, during this somewhat lengthy, goes for several pages bench conference, asked the defense, okay, when you're arguing about relevance, not relevance, are you going to argue it in closing? Yes.
Well, certainly, if you put it on,
Why?
it's going to have to.
Pardon me?
If you put it in evidence, it's going to have to. But he
Yes.
was urging it not to go into evidence, was he?
Right, and the judge was saying, if you are all not going to argue it, then it would seem to be not relevant. And this was before the judge was ruling it admissible. Only ruled it admissible when they said, yes, we are going to argue it in closing, and also, yes, that is our point, that this is the genesis of making the statement. So regarding the actual content of, if we go to your point, Your Honor, is not the...
I think my point is that this scene had virtually no relevance, even given your argument for why it was relevant. Because you're trying to rebut a supposed assertion that she got her idea to make this allegation from the movie, and yet you only show the jury. I don't know how long the scene was. It was pretty
Less than 4 minutes.
Yeah.
Approximating 4 minutes.
So how would a jury be able to draw that conclusion from watching less than 4 minutes of a movie?
Because if there was anything more in it that was going to...
The jury would have to speculate, would it not?
The defense would do their part and say, no, you need to see it in context because it's misleading in this isolated clip. I mean, if another part was shown...
Indeed it is.
Pardon me?
Indeed it is. If that's that clip is just the one clip. It's not the whole movie. It doesn't say what happened during the movie other than that one clip.
And again, it was the part that, the child said this was not what happened to her. But there was, without the jury seeing it...
The child doesn't describe this particular segment. This particular segment wasn't shown to the child, was it?
She saw the whole movie.
Right.
Child saw the whole movie. And she does say what...
In her testimony, she doesn't talk about the 3-minute segment.
She talks about what happened in that film. She says that the girl was raped, and that did not happen to me.
Right.
Right.
But so the state then showed the jury a clip of the movie in which the girl is raped.
Yes.
Okay.
Based on the defense inserting that film into this trial from day one.
Well, the film is fairly significant, in terms of whether it's relevant or not. The film, at the very least, is the occasion. And everybody seems to agree the occasion for her to first speak about this.
No, incorrect, Your Honor. She first spoke about this to her friend, JJ. So there were 3 disclosures by the child.
Okay,
The first...
She spoke to one of her friend who watched the movie with her. She spoke.
That's the second time. The first disclosure. Now that was, the implication, but that is just factually incorrect because the first disclosure was to the friend JJ on a camping trip.
And the mother learns, as she testified, pretty much immediately thereafter, the film.
The disclosure, yes, but there are 3 disclosures by this child. The very first one before the film is...
One of them is on the occasion of watching this movie.
Yes, that's to the AC child friend. And then after that is the friend at school.
I don't know how that gets you to show in the movie.
It wasn't our intent to show the movie.
You showed the movie.
In light of the defense, starting with every filing, the motion in opposition to the hearsay, saying that it's not reliable because it came as a result and after the showing of this movie. The judge's order on finding the hearsay admissible expressly addresses this movie and its implication. I mean, from the get-go, out of the gate, this movie...
So because of arguments they made in trying to prevent the admission of the hearsay, you get to put this movie on.
No, Your Honor. Not just that. It's everything. It's like the allegations are regarding a 2009 incident, right? And we don't have a disclosure until 2012. So we have a late disclosure right off the bat. So the child's subject to credibility challenges based on that. We have the movie being used as an impetus. Now, during voir dire, the defense asks the jury, because they're not saying the child's lying, they're saying, do you believe that a child could think she's telling the truth based on improper influences? So these seeds are planted.
All right, so now, tell me what in this clip would rebut any of those assertions.
That the sexual contact here is different than, she could not have gotten the substance of her allegations based on this.
The sexual contact in that scene.
Yes.
Okay. How is that relevant?
Because it was different. She
In
couldn't.
that scene. But the jury doesn't see the whole movie, does it?
No, but if there was anything else in there, we sure as heck would have heard it from the defense.
I'm sure the jury might speculate about that. Is the jury supposed to speculate about that?
No, they're supposed to consider the evidence that,
Is presented.
yes. Let's, for the sake of argument, put aside that this clip somehow was erroneously admitted. You still have the standard of review of abuse of discretion here, and whether or not, now the judge didn't consider it error, considered it relevant based on everything that happened in this trial. So this admission of this clip has to have vitiated the entire trial, and in this case where you have the compelling Williams Rule witnesses who testified in this case, to one of them an almost fingerprint identical kind of similarity. We have the trial judge who was acting as a vigilant gatekeeper, and that judge...
He didn't watch the clip beforehand, though.
No, he did not, but he had a very specific representation of what was in it, and the defense didn't argue that he should have watched the clip, and the defense counsel himself said, I haven't seen it yet, and the defense cites the case of Lowry for an abuse of discretion and admitting evidence in there, hardcore child pornography, that was admitted without the judge viewing it, and in that case, the court says, the judge, number one, it also was related to pornography charges, which were not... that instant pornography was not the substance of that, but the judge the opinion says vague, if any, details. Here we have a representation.
Regardless of whether the judge viewed it, I mean,
Right.
it's up to us to decide whether this piece of evidence...
It is, in light of the whole trial.
Prejudicial.
Absolutely. Absolutely.
And so whether he viewed it or not really makes no difference.
You have to decide whether this piece of evidence vitiated the trial in the context of all the other evidence admitted.
Well, no, because we have to decide whether this was, the prejudice outweighed any relevance, and such that it was error to admit it, and then we apply a harmless error test, do we not? In which, in that case, the state has to show beyond a reasonable doubt that it could not have affected the jury's verdict.
The admission of evidence is subject to an abuse of discretion standard. So we do have to start there.
But if we conclude that it was an abuse of discretion, I don't think we have to decide that evidence vitiated the trial. I think we have to decide whether, notwithstanding the erroneous, admission of the evidence, the error was harmless.
Yes. If you're going to look at because the trial judge did not find it error, so we are looking at whether it was in his discretion in finding it admissible. If you find there's an abuse of discretion in finding this admissible here because of the prejudice or whatever, or tangentially relevant, which it was strongly relevant in this case, and so that is a balancing test. How relevant is it compared to how prejudicial is it? Okay, and I understand your biggest concern is the fact that they saw the clip as opposed to the whole thing.
Well, my big concern is only watching a clip renders it gives it virtually no relevance whatsoever. Because the purpose for which the state asserted that it was admitting it can't be accomplished just by watching a clip. And this clip that was shown, I've never seen the whole movie, I've only seen the clip. Pretty powerful stuff. It's bound to...
The trailer also...
I never watched the trailer.
Okay,
I've
so...
only watched the clip.
This was not an issue that was brought up below, though, so we're going to have to look towards the fundamental.
The admission of this clip should not be admitted because it's unduly prejudicial.
By a defense
minimally,
attorney.
if at all, relevant. But
By the defense attorney who hadn't even viewed it himself.
understandable, but we're stuck with, regardless of whoever viewed it to begin with.
Okay.
That argument was made and the clip was shown, so now
Yes.
we're stuck with looking at it and trying to decide, and doing that 90.403 balance, right? Look for some relevance, balance that against the potential prejudice.
Okay. So
And once we make that determination,
then we move to harmless error.
Then we move.
If you were
decide
finding
it was
error,
an abuse of
if you
discretion,
find that.
we go to harmless error. Not
Right.
this has to vitiate the whole trial.
Right. And this, I would say then, is the one example where we're not talking about vitiating the trial, because we are talking about that divulging, because that was a mistrial and that was denied. But here, because the objection was essentially overruled based on all the issues that were discussed.
Right.
So yes, then we are
So
talking
the
about harmless
question
error
is,
here.
Yeah, on the other question, if the question is was the vouching so bad that notwithstanding the curative instruction, it vitiated the trial? That would be
Yes.
a different kind of issue.
Yes, yes, based on the fact that this was overruled. So we look at the evidence. So we have the consistent allegations of the child. We don't have inconsistencies in her statements. We have faults in the witnesses they're cleared up on cross-examination.
But you also have a child whose memory is somewhat faulty and who responds on numerous occasions, I don't know,
True.
or language to that effect.
And who once previously said nothing happened.
Yes. Now this is where we talk about opening the door, and this is the only case. We were talking about opening the door with this film. We're talking about the relevancy and the mission. The opening door came in. Now the mother asked her, did something happen, between you and Mr. Cavalier? And the mother asked that question because she had seen his mugshot for possession of child pornography. Now that was the specific circumstance which initiated that question, which the judge was very carefully and even interrupted closing argument to make sure the door did not get open, because that would clearly be prejudicial. And but the state was not allowed to ask them, or no one was allowed to ask the mother, whether she asked it so that door remained closed, and that the child was asked, did you deny it? Yes, and she did deny it to the mother. So that was the single inconsistent statement, was that one denial to the mother, and she never made any admission to any adult. She only told her friends. First JJ after camping, then the Facebook troubles, watching the film, telling AC, then the third child, the friend at school, who then goes to the teacher, and the proceedings are, reported to authorities in that sense. So if we look at her statements, which is why, of course, she is going to be attacked on credibility, she is going to have problems with holes in her memory, because it is a late disclosure when it comes forth. But she remembers the critical things, including what she's wearing. And we have then the Williams Rule, which is very compelling. So compelling, the defense even addressed it in voir dire, talked about the powerful Williams Rule, and they wanted not a commitment from the jury, but they wanted to know, are you going to feel where there's smoke, there's fire, if you hear that there are similar witnesses. So those two witnesses, really are what, in this case, save the conviction from any reversal based on the vouching issue where they got a curative instruction, and a view of the film which I had not anticipated being at issue. So you also had the accusation to the defendant after the fact, and I can't, those circumstances of those Williams Rule witnesses, the first one, not the Disney World one,
I think you have
but
to be careful about that, because I don't think you want to rely too heavily on the Williams Rule evidence for your harmless error showing, because now you're talking about them really becoming a feature of the trial.
No, it depends on that's like weight versus quantity. If we were harping on it to the jury regarding, you can't consider this other evidence, and letting that overtake it, and the judge made sure it didn't overtake it by excluding the mother who witnessed her child being carried while she was sleeping during a sleepover to the back towards the defendant's room. You're not going to have that in, because inherent in the child who testified herself regarding the waking up in his bed to the identical touching, except for over the underwear compared to under the underwear, that was inherent, that she was carried. So the judge, in being cautious, excluded that evidence. So we have the consistent allegations of this child. Yes, there are holes in her memory, not regarding the actual events, but regarding, what did you do earlier that day? What did you do after that day? she was going to be subject to a credibility attack based on the late disclosure, based on holes in her memory, which is why the judge found in the orders on Williams Rule and hearsay that it was especially relevant to corroborate her testimony, because there was no physical evidence, as there would not be with the nature of these charges, even if it was the next day, as opposed to, 3 years later or however far it is. So we have the child's consistent statements, but for the one denial to the mother, and even to the date of trial, it was, let me take that back, I'm not sure about that, but I know she had, maybe it was at the hearsay, she had not disclosed to the mother. The mother heard it through the school authorities. That's who she told. The child was afraid to tell her mother for whatever reason. There is evidence that the relationship was based on the mother had a friend that was friends with the defendant. So maybe she felt that would be like some bad, I don't know. But she did deny to the mother. That's a single inconsistent statement. Other than that, right down the line, consistent with her allegations about what happened, consistent with what happened with the Williams Rule witnesses. We have the defense when he's confronted. And this isn't the most compelling evidence, but it is evidence tending towards a guilty conscience. We have his response, white and shaking, when he hears who it is. Why? Because she pretended that she was asleep. So he didn't even know. I don't want to go into what he knew or didn't know, but her testimony is she pretended to be asleep as this was happening. She was afraid, and she actually fell back to sleep, and then woke up back in the morning where she went to bed. Should we talk about vouching?
You're right at the end of your 20 minutes. I'll give you a couple extra because I helped you use that time.
Okay. The curative instruction, first of all, the teacher's testimony clearly relevant, especially when her effect had been challenged from the get-go too, regarding at the hearsay hearing, that the child the deputy said she had a flat effect, was argued for again for why she isn't reliable. So the child, the fact that there was this change in behavior, supplemental authority cited by the defense, the Lee case actually supports the fact that the teacher's testimony of her observations do come in. Lay opinion when they go to a mental state is admissible when it's things like angry,
but can
mad.
they make an attribution about why? Can the witness say this is why?
Oh, absolutely not.
But
no.
I don't recall whether it was the teacher or the counselor who gave she seemed really happy afterwards.
The teacher gave...
She didn't expressly say that was why, but she all but said that. After she came to me and told me this, it seemed like a big burden had been lifted off.
Yes, true. And that's appropriate. It's appropriate under the cases cited in the state's answer brief regarding a change in a child's behavior.
She didn't say afterwards she seemed happy. She said it seemed as if after she talked to me, it seemed like a big burden had been lifted off her. That seems to be an attribution for the reason why she seemed.
Which was fodder for cross-examination, which the defense did argue in closing argument that the teacher didn't know about the Facebook troubles, and now she's off the hook for Facebook. And the case cited by the defense, Lee, does go into what's not allowed is a statement of undisclosed intent. So we don't have that. We have a statement of a condition, her describing a condition. It looked like a weight had been lifted from her shoulders, relieved. We know what relieved.
At least as to the teacher and the guidance counselor, the jurors' questions suggested they may not have found that those witnesses were vouching because they asked 2, if not 3 questions.
Absolutely.
Do you believe this?
Thank you for reminding me of that. Yes. So they did not misinterpret that because they specifically sent the jury question up to the teacher, did you believe the child? And of course, that wasn't relevant and the question wasn't asked, but clearly the teacher did not feel that way.
But again, going back, the trial court, although in one instance he fails to sustain the objection, I think it's clear from the record that he found there was error.
The one about the kinesics, when they're talking about kinesics in the cookie jar, they stop that.
Yeah.
I'm sorry.
Kinesics, and on one level,
yes.
It seems that he feels that the teacher's testimony may have crossed the line. But many times it appears that he's not sustaining the objections, but he's not overruling them.
The judge was concerned about the teacher's testimony regarding before his determination was made about the time frame, that it was narrowed to surrounding so that it was relevant to the surrounding this disclosure. But that was the only concern there. And the judge effectively sustained the kinesis kinesis argument by saying, well, he's not going to be talking about kinesics, and the state says, I'll move on. And so that was done, and there was no request for a mistrial or curative there, and that was an effective sustaining of that objection. So then we go into the...
Before I forget it, there are instances where the curative can overly emphasize the error.
Yeah.
And I question whether or not this was one of those instances. Because in the curative, I want to think the judge on 3 or 4 occasions reinforces no witness can vouch.
Yes, well, I guess it's kind of a quandary, a catch-22, right? Because the cases do say, and some of these cited by the defense and the supplemental authority regarding curative instructions, which are insufficient. They, number one, they were belated. Of the 6 cases, 3 of them, the 6 cases that were on vouching, 3 were overruled, 2 were belated instructions. 1 was a timely one, but based on the evidence, it didn't cure the error. So, and some of the reasons why the instructions have been deemed insufficient is, they're not timely, ours was timely, and also they don't refer specifically to the objectionable testimony. So yes, we do have on 404, I won't use the time with it, but the judge directs them to the testimony that they are to ignore, and you are the only ones. Anytime an officer, any witness, and this was all developed also in voir dire. Voir dire was brought up by the judge, just because someone has a lofty title, law enforcement, pope, you don't give them extra beliefs. The state even said, law enforcement officers, you have family that are law enforcement, or anyone give them extra, no. So all these, taking as a whole, all of these efforts towards ensuring that there was a fair trial were put into place here, especially with this prompt curative. Anyone that suggests they thought the witness was or wasn't telling the truth, it is legally irrelevant, and the only people that will make that decision are the 8 people sitting in that box. So please disregard that comment. Right after it came from the detective, and then moved on.
You probably need to wrap up, Ms. Bevington.
Based on the evidence in this case, the Williams rule, the consistent allegations, the guilty response by the defense when he is confronted, any error is harmless. Nothing reaches the level of an abuse of discretion for the admission of evidence, first of all, and also as for the denial of a mistrial, and the curative in this case would have taken care of it. We ask you to affirm the judgment sentence. Thank you.
Did a good job under fire.
I'd like to first talk about harmless error. No physical evidence, no medical evidence. The only case for which he was on trial was what this child was saying. As Judge Crenshaw pointed out, she said, I don't remember, I don't recall, numerous times. Might have been over 20 during at least one of the motions. Additionally, the Williams rule witnesses. Number one, as part of the issue on appeal, argued they became a feature of the trial. Number two, one of the Williams rule witnesses said, this supposedly occurred when she was 4 years old in Orlando, testified during a deposition that nothing bad...
4 or 5?
She equivocates on that, Judge. I want to say that she said 4. I don't specifically recall. But she said during a deposition that nothing bad happened between her and the defendant in the motel room. I'd further argue that it's pretty significant that in addition to the child's memory issues, she tells her mother, the one person who she should tell what happened, nothing happened between me and the defendant. Nothing bad happened.
In terms of the harmless error analysis,
yes, ma'am.
It's undisputed on these records that the 2 Williams rule witnesses had no connection to each other, right?
That's undisputed, correct.
At least as to one of them, she was not impeached. Motive, bias, interest for testifying in the manner that she testified.
The only way that she was impeached, and Your Honor is referring to, I believe it was Ms. Testa, was that it was late reported, she never called the police, things of that nature, in terms of prior inconsistent statements, bias or motive. I believe that there was also some mention about she read some newspaper stories.
But even when she read the stories, she doesn't come forward.
That's true. The detective actually went out and found her and then brought her forward.
And as to, I will call her the Orlando Williams rule witness.
Correct, Ms. Barber.
She was impeached based upon her testimony, and I believe the first trial.
Correct. The deposition.
The deposition.
Yes, ma'am.
That defense then introduced as substantive evidence.
Correct. Correct. Furthermore, I'd also note, in addition to the child's memory issues, the prior inconsistent statement, although it was fleshed out a little further on cross-examination, I would still point to the fact that as she's watching this movie, she tells her friend it happened at my cousin's house when I was 4 or 5, not at the defendant's house when she was 7 or 8. Different location, different age. In terms of the teacher vouching for credibility, it's okay for one witness to say someone was smiling, someone appeared happy, but that's not what the teacher did here. What the teacher did is saying, after this child told me the story, it was like a weight had been taken off of her shoulders. She seemed, basically the teacher admitted she's speculating about the child's intentions. The problem, the state cites 2 cases, one which came out in the 4th this past year, which is the Petrucci case, and one called Elsie, which I believe was out of the 1st District Court of Appeal. If you look at those 2 cases, what specifically happens, at least in the Elsie case, is we're talking within days and weeks of the alleged abuse. In this case, we have 4 or 5 years. And if you look at that testimony, the mother of the 17-year-old teenager in the Elsie case said that her daughter was clingy, she wouldn't go to the bathroom by herself, she was having nightmares, things like that. If you look at the Petrucci case, which involves a stepfather and a stepson, again, the defense theory was what the overprotected mother planted this in her memory. The child in that case was wetting the bed, having nightmares, and going to counseling. That's not the testimony that occurred here from the teacher. What the teacher said was she was happy. The implication from the teacher is, it's my opinion as her teacher for this year, because she told me what she told me, weight's taken off of her shoulders, therefore she feels better. The implication is to the jury is because now she's feel better and unburdened herself, that what the child must be saying is true. Also, if the court looks to Florida statute as it relates to opinion testimony, 9701, it says that a lay witness is entitled to give their opinion so long as they can't reasonably communicate that using other means. And, number 2, it doesn't mislead the jury to the prejudice of the opposing party, which is precisely what happened in this case with the teacher, which is like the Lee case I cited as supplemental authority, which I referenced the court to. In addition, in terms of the curative instruction, the 2 most instrumental cases, as I was saying, were the Acosta case and the Tumblin case. If you look in the state's answer brief, they cite a case called Salazar. That's the only case that they cite as it relates to saying that what happened and what happened below is okay. The Salazar case was specifically referenced by the state in their answer brief in the Tumblin case, and the Florida Supreme Court rejected that. The key focus there is who was the witness. Was the witness a key witness? In the Salazar case, the witness was a detective who was not a key witness. He was saying that there was truth. He was looking for the truth in his investigation. That's absolutely not what we have here. We have a seasoned detective, 20 years of law enforcement experience, 464 hours of advanced child abuse training, giving his opinion, whether the juxtaposition or not, that he thinks this child is being truthful.
Okay, Mr. Crawford, your time is up.
Thank you, Judge.
Thank you both very much. With that, we are adjourned.